Good afternoon. My name's Doreen Hartwell, and I'm a lawyer in Las Vegas, Nevada.
Hi, good afternoon from Oregon, your state. I'm Erin Lageson, and I am the presiding judge of Department 3 of the Oregon Court of Appeals.
Stephen, you're muted.
Yeah, the boomer forgets to unmute his mic. My name is Steve Jewett. I'm a county court judge in Orange County, Florida, which is Orlando. And yeah, that's me.
And you may introduce yourselves.
Hi, we are Unit 5 from Grant High School in Portland, Oregon. My name is Ava Phillips.
I'm Talia Baskin.
I'm Zoe White.
I'm Makoto Powers, and our teacher is Miss Dee Pasquale.
So the question today will be question number 1. A result of the decision in Wisconsin versus Yoder is that, quote, any parent/guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs, end quote. Do you agree or disagree with this result of the decision? Why or why not? What words, if any, are found in the U.S. Constitution or in state constitutions to protect the right to an education? And finally, how have courts balanced religious beliefs with other rights? You may begin.
We do not agree with the holding in Wisconsin v. Yoder. We believe that the law in Yoder was sufficiently narrowly tailored to address the government's compelling interest in ensuring that all children have a high school education. Furthermore, Yoder only addressed the religious objections of an Amish sect to compulsory high school education and did not hold that a parent can remove a child from school if they objected to the curriculum on religious grounds. Rather, the Amish Heritage Foundation argues that this may be a future holding. This case represents the tension between the free exercise clause of the First Amendment and education rights.
The U.S. Constitution does not mention education, and the court ruled in San Antonio v. Rodriguez that education is not a fundamental right. However, both states and the federal government have grappled with equal access to education. The court has protected education in some controversial areas, such as Brown v. Board of Education, Plyler v. Doe, and Grutter v. Bollinger. Because of the 10th Amendment, education decisions are primarily up to the states, and all 50 states have some form of an education provision in their constitution. However, the contents of these provisions differ drastically from state to state. Alabama's constitution includes a provision for segregated schools. Washington's requires the state to fully fund education, and Virginia and Illinois call for high-quality education.
This right to education clashed with the right of freedom of religion in Yoder. The First Amendment right to religious freedom is split up into two main categories, the Free Exercise Clause and the Establishment Clause. In Yoder, the parents made their claim using the Free Exercise Clause. The Free Exercise Clause protects individuals from government interference with the practice of their faith. But the interpretation has changed frequently from the generally applicable law test in Reynolds v. U.S. to strict scrutiny in Sherbert v. Verner, and then back to the generally applicable law in Employment Division of Oregon v. Smith. In response to this change, Congress passed the Religious Freedom Restoration Act in 1993, which applied strict scrutiny to issues of religious freedom for federal cases.
Courts have struggled to balance the First Amendment freedom of religion clauses against other rights. In many cases where two rights are in conflict, the Supreme Court has used procedural examination to avoid choosing one right over another. In Masterpiece Cake Shop versus Colorado Civil Rights Commission, the court declined to address the conflict between the Free Exercise Clause and an anti-discrimination statute, and instead decided the case on procedural grounds. On numerous occasions during the pandemic, religious rights have conflicted with COVID-19 restrictions. Recently, in Tandon v. Newsom, the Supreme Court favored a religious claim over the compelling government interest for public safety. In Yoder, we think that the court improperly prioritized religious freedom over the importance of a uniform quality education for all. We agree with Chief Justice Warren in Brown versus Board of Education, in that education is required in the performance of our most basic public responsibilities. It is the very foundation of good citizenship. We believe that the court should have placed the educational rights about the religious objections raised by the Yoders and kept the students in school. Justice Douglas wrote in his dissent in Yoder that if a parent keeps his child out of school, then the child will be forever barred from entry into the new and amazing world of diversity that we have today. Thank you. We're ready for your questions.
Thank you. First up, in the context of constitutional law, what does separation of church and state mean?
This means that the government cannot fund or kind of associate with a religion. It came from the history behind it is that the founders were familiar with in England, where there was a religion associated with the state, and they feared this. And so for that reason, we have the Establishment Clause in our Constitution.
James Madison wrote that the purpose of separation of church and state is to keep forever from the shores of ceaseless strife that had soaked the soil of Europe in blood for centuries. And I think that this kind of articulates how the founders were really scared of what had happened in the religious wars in Europe and kind of this culmination of events that led up to the Constitution being written.
The separation of church and state also protects minority religions. In England specifically, the Puritans were a minority religion that were kind of forced to not practice openly, and that's why we have the freedom of religion in America today.
Oh, I think you maybe
Should,
muted.
yeah, I know. Well, my dog started barking, so I turned it off. Oh, I'm sorry. Go ahead. Did you have a comment? No? Okay. Should students, public school students, be allowed to take part in religious clubs on the property of the public school? Should that be a problem? Is that establishment? Why or why not?
In Mergens v. Board of Education, the court held that if you want to have a religious club, then you should be allowed to do so. Now, this school was under the Equal Access Act, which was a funding statute that said you had to provide equally for the strict scrutiny classes. And because of this, even though the school initially denied the club under an Establishment Clause claim, the court held that under the Equal Access Act, the club had to be approved and that the Equal Access Act did not violate the Establishment Clause.
The case that Makoto mentioned is an example of when the Free Exercise Clause and the Free Establishment Clause have come into conflict. Another example of this is Lee v. Wiseman, where the court held that government involvement in a state-sponsored religious activity in a public school is unconstitutional because of the Free Establishment Clause, even though it was the free exercise right of the teacher to do so. That was the conflict.
To answer your question, in a public school, you may have a religious club as long as each club is treated equally to each other.
I also think it's important to mention that in Board of Education v. Mergens, the students were high school students, and so they were more likely to understand that the school allowing them to have this club was not establishing a religion. So in cases of younger students who are easily coerced and could believe that the school is establishing a religion, it may be decided differently.
So the age of the student or the grade of the student could potentially cause the Supreme Court to go in another direction, is what you're saying?
That's
Yeah.
correct, yeah.
Okay, all right.
How should a student's right to an education be weighed against a parent's religious belief?
Well, to articulate Justice Douglas's dissent in Yoder v. Wisconsin, he thought that the student's educational right was kind of overlooked in this case, and that it should have been prioritized over the religious right of the parents, seeing as this is kind of an irreversible decision to pull their child out of school, and it could cause other problems if the child did not agree with the religious rights of the parent, or the religious beliefs of the parent.
He thinks that if an Amish child desires to attend high school and is mature enough to make that decision, that the state may be able to override the parent's claim and use the student's claim instead.
Is that where you guys stand? You agree
Yeah.
with that?
Yes.
That's
Yeah.
correct. Read it.
Alrighty.
As you mentioned in your prepared remarks, recently the court has dealt with a lot of free exercise case, including Masterpiece and then some of the pandemic-related cases. And one question that the court has struggled with is how to determine whether a law is neutral to religion. What factors should a court look for in determining whether a law is neutral towards religion?
I think specifically the court should look and see if the law is generally applicable, meaning that it applies to all people that of a religious sect or not.
And this doctrine comes from Employment Division of Oregon v. Smith. However, recently, criticisms of the court in Tandon v. Newsom, which was the most recent COVID-19 case, where the Supreme Court ruled that Bible study in a house was acceptable and they should have made a religious exception for that in the California statute. But recently, kind of the court has been maybe overlooking the generally applicable law test in order to find a religious exception, which Justice Kagan said was comparing watermelons to apples.
So you agree that they're overlooking, they're just looking past their previous test inappropriately?
That's correct. Specifically in Tandon v. Newsom, the court used something called most favored nation theory, which says that if you provide an exemption for one sort of activity, then you have to provide an exemption for all activities. The way they applied this is that in Tandon v. Newsom, the California statute said you can have no more than 3 families gathering in a household. And yet grocery stores were open. And so the court said that, well, if you have grocery stores open, then people should be allowed to congregate in houses to worship and practice their religion. And because of this, the law actually substantially burdened religion and was discriminating against them. And so in that way, they ruled in favor of religion and said that the law was unconstitutional.
We see, or we feel like these cases were wrongly decided because when we see the conflict of public health and religious freedom come into contact in both Tandon v. Newsom and Roman Catholic Diocese of Brooklyn v. Cuomo, we see that they are favoring religious freedom over the compelling government interests of public health. And in this pandemic, we've seen over 500,000 people die. And I see that there's alternate paths to practicing religion, but there's no alternate paths to bringing back these victims of this pandemic.
I think a James Madison quote applies to the situation, which is that liberty may be endangered by the abuses of liberty as well as by the abuses of power. And I think that when one right, no matter how important it is prioritized disproportionately over another, it does put rights at conflict and can be a danger to the rest of the ordered scheme of liberty we have in this country.
While I agree with my teammates, I think it is important to show the difference between Tandon v. Newsom and Roman Catholic Diocese versus Cuomo, because while in Tandon v. Newsom, the court kind of got the facts wrong of the case, in Roman Catholic Diocese versus Cuomo, the statute in New York was targeting religion.
Great.
Good job. Well done. Excellent.
When you think
Go ahead. I'll just jump in real quick. I really liked your statement, your guys' prepared statement. It went from A to B to C to D and laid it all out there. It had a little history. It had a lot of law. And it was really, I think it's maybe one of the best I've heard all day, if not the best, just because of that. It was extremely clear. You knew where you were going, and each one of you had a little piece of that, and it really came together extremely well. I agree with you. I think that Yoder is a bad decision. I agree with the dissent. So, of course, I might be biased towards your arguments because I think you're absolutely right. And the other stuff that you guys did, I mean, when we would ask you a question about something, you're answering our questions. You're not dodging. You're not falling back on some prepared or memorized, oh, well, I'll just throw this case out there. everything seemed to be germane and was on point and exactly right. And I especially like how you were drawing a distinction between the Tandon case and those cases that are those most recent cases, because there has been, and I have a tendency to agree. I think you guys even said it, is they're changing their standard to back up their political beliefs. There, I said it. But I think you guys did a really good job. It was extremely enjoyable. These things, to me, if I want to spend another 30 minutes or an hour with the students talking about issues, means it was good. The time went by so quick here. I have so many more things I wanted to ask you guys and talk to you guys about. Thank you very much for letting me be a part of it. Good luck.
Thank you.
Thank you so much.
I guess I'll go next. I probably don't have too much to add. I really enjoyed your presentation. You did a great job of covering a range of materials to support your answer in terms of history, what led to us adopting the protections for religion in this country, to good quotes from James Madison, to a real comprehensive understanding of the case law. And I especially appreciated, which we haven't always seen today, is you seem to have read or understand the entire cases and understand the different perspectives of the different justices, and are able to articulate how the theories are changing, and recognize also, I think that this is an area where the law is changing now, but you accurately described that the arc of the law in this area has never it's not been a static area, because it's so difficult. But wonderful job. I want to keep talking.
Yeah, excellent job. Just really, really well done. Your prepared remarks were totally on point, and you thoroughly answered every aspect of the question. I mean, from the general to the specific. You included and Steve kind of covered it from just A through, I'd say, Z. I mean, you really covered everything, and I loved your use of quotes, historical quotes, and quotes from the various cases, and it just really created a nice imagery in support of your position and arguments. I thought that was just really well done. You did it in your written remarks, and you did it in response to our questions too. You addressed the issue with regards to the state constitutions and the disparity between the different states with regards to the right to an education. I thought that was well done, and your participation from all of you. Everyone had something to add. Ava, you ran out of time when you were about to tell us, how the Supreme Court and why the Supreme Court got Tandon wrong. And I love that you said, no, they got the facts wrong there, and so it's like wrong facts, bad result kind of thing. So that was great. You guys just really demonstrated a mastery of the information, the subject matter. And it was such a joy to end the day on this super high note. Thank you.
Definitely. And you're definitely the only team that has quoted us from a Kagan dissent, for sure. So that means you're reading the cases. Means a lot to me as a law nerd. I like to see that you're actually not just reading the head notes and spouting that back to us. Really, really, really good job. Congratulations, guys.
Thank you
Thank
so
you.
much.
Well done. Well done.